Welcome back to Youth Justice Transformation in Action, our podcast for youth serving stakeholders. We are the RFK National Resource Center for Juvenile Justice, and we are on a mission to transform the youth justice system by partnering with people like you who are passionate about improving outcomes for youth, families, and communities you serve. In this podcast series, you will hear from experts in the field and on the ground who have championed reform on the local, state, and national level. We are your hosts. I'm Jody Martin.
I'm John Toole.
And I'm Michelle Darling. In this bonus episode of One Youth, Dual Systems, we continue our conversation with Jessica and Judge Johnson to go more in depth about dual status youth, such as why they are at risk for sexual exploitation, more ways to collaborate with system partners, creative solutions to prevent youth from deep-end involvement, and why impassioned advocates make for a better system. To learn more about dual status youth and CSEC, visit our website, rfknrcjj.org. And don't forget to contact us at rfknrcjj@rfkcommunity.org or on Twitter at rfkyouthjustice to share your ideas for topics and guests for upcoming podcasts. Now, let's jump back into the conversation.
Jessica, continuing our conversation about the population of sexually exploited and human trafficked youth, why are multi-system involved youth particularly vulnerable?
The research we have tells us that exploited youth have often experienced abuse. In fact, we have studies indicating that between 70 to 90% of exploited youth have a history of childhood sexual abuse, and many of them have come in contact with our child welfare systems. Other risk factors for exploitation are specifically related to youth's experiences within the foster care or the delinquency system, such as being placed in congregate care settings. We know that traffickers target these facilities, knowing that there are vulnerable youth there. We've also not solved the problem of children running away from care and ending up in vulnerable situations, such as on the street, needing shelter, or depending on peers who may be involved in exploitive activities. And all of this puts children at significant risk. And I wanted to point out that many of our runaway youth, those who are running from home or those who are running from foster care, they identify as LGBTQ+, and thus this community of kids tend to experience exploitation at high rates. And I do just want to take a moment to highlight something that Dr. Bruce Perry has noted about CSEC victims. It's the fact that they have likely experienced lifelong trauma, and that some of the prevalent patterns that become normative for them include violence as a means of communication, feeling a sense of deep worthlessness, a distrust of people who may be in positions of authority and available to try to help them, and a belief that their body is an object to be hurt. And I point this out because I think this describes patterns that we see among youth who are dual status as well. And that's part of what makes them particularly vulnerable to those who seek to prey on traumatized kids.
As a former probation officer, I know during my practice, I interpreted those responses as recalcitrant, as resistant, as oppositional, as non-compliant. I would hope that with this awareness that you all are sharing, that we work as a field on behalf of these youth to understand that that's the way their world sees our world. They've been impacted this way. I'm going to shift a little bit because I want to highlight more of what I think is part of your expertise, Jessica, that I'd want shared with the audience, but certainly part of Kai's focus, Children's Advocacy Institute, and that's that you do work around understanding what resources are necessary in a community to serve these youth. We don't just want to identify them. We don't just want to be aware of them. We want to have the services in place to interrupt this pattern or support the change in behavior. Can you tell us a little bit about the work you do around that?
Sure. So we have federal law that requires child welfare agencies and system partners to identify and report and document about youth who are at risk of or experiencing sexual exploitation. And they also are required to coordinate on ensuring that children have access to services. So when it comes to what resources or services are necessary to work with commercially sexually exploited children, they're really a lot of the same resources that are necessary to help serve youth and others in our systems overall. But the way that they might be utilized can be somewhat different. So there was a great document that was put out by California's CSEC action team about the holistic needs of commercially sexually exploited children. And we use a lot of that information at our Children's Advocacy Institute when we provide technical assistance to kind of do an inventory of what resources are available and are they accessible to youth experiencing this kind of exploitation. And just kind of broadly, what it highlights is that there's a need to recognize that the path for CSEC recovery is not necessarily linear, that there are stages of change that are common. And a lot of that is because of what we discussed about kids not necessarily seeing themselves as victims and just the really extensive trauma that they've been through. So all the resources absolutely must be trauma-informed and victim-centered. And so a key consideration is recognizing that kids may want to go back to their exploiters. They may run, they may go back to their exploiters, and we need to let them know that they have a safe place that they can come to. So our resources are really about saying they're here for you when you want to avail yourselves of them. And they are going to be specifically geared towards understanding the difficulty and the challenge of recovering from this experience. So one of the things that I'll just highlight that it can be so important is ensuring that there's work with community-based organizations that will allow for survivor advocates or youth advocates, either those who have experienced the same kind of exploitation or somebody who's been part of our youth justice or child welfare system, who really is, kind of that credible partner and advocate to really understand where the youth is coming from and help them navigate through a lot of the resources, being medical and health related resources, housing resources, legal resources, getting restraining orders, some things that are a little bit more unique to this population, but a lot of them are just meeting basic needs. And being able to do that will help avoid kids, going back out onto the street or going back to their exploiters. So we need to be patient and we need to partner with them on helping empower them to meet their own needs.
Judge Johnson, I'm anxious to connect Jessica with you and your staff as a follow-up to this as well, just because I believe you've engineered a group of folks that come together, and many of the things that Jessica says about what we need to be as we work with these youth in Hancock County is representative of your staff. I think I've had a chance to work directly with many of the probation, with the children's services, with the workers that you're privileged to work with as part of your team. And I think that same kind of patience, that same kind of understanding seems to be just a part of the way in which they approach the work with the youth and the families in your dual status initiative. But the challenge of being patient when we need resources, that moment, can you comment a little bit about that and how you approach that in Hancock County?
Some would say I'm not patient at all because I just want what the kid needs to be addressed right now. But, we can't get it all done immediately. I think having team members that are willing to sit down and talk about what it is exactly that needs to be addressed, talk about what their barriers are, why they can't. It's very easy for, one agency to point the finger at the other agency and go, well, they're not doing this, or they're not, well, you're not doing this. But in reality, I think everybody has those requirements that they need to follow. And once we truly understand what everybody has to do for their job and everybody's on the same page, then we can better address all the other things that we need to add. So we need to be working together before we need to be doing a smaller part well before we expand into multiple things. So
well, for me, Judge, I would take that and say, in many jurisdictions that begin this work, it's a deficit-based discussion. we don't have this, we don't have that.
Mhm.
And while that may be true, we need to flip and understand what resources we do have that may serve. And over time, I'll take the patient statement and apply it to something different, Jessica. We have to be a little bit patient despite the urgency of today's critical case, and recognize that we still need to assess for what those needs are for those youth. And over time, we can create an aggregated need for that service. And perhaps because we've built a collaborative, we may be able to identify sources to access those kinds of resources through grants and reallocation of budget funds to make sure the necessary services and treatment programs are available for these youth. We must therefore create systemic solutions that embody all the principles and tenets that Jessica spoke to previously. I just want to ask the importance of really clearing, and I often say working through, not working around, the traditional information exchange, information sharing issues that confront multi-system approaches that need to be developed for this work. Could you comment a little bit about what is important? What are the opportunities we have when we address the information exchange issues for these youth?
Sure. Information sharing scares people. The 5-letter words, as I call them, HIPAA and FERPA, are federal laws that just immediately people's gut reaction is, oh, we can't share. We can't share any information about health, mental health, education, all these things that can help us better understand where risks are coming from or what children's needs are. There's just kind of this wall that comes up. And I would offer that most of the actual barriers are based on a misunderstanding or ignorance of the law. The law is there to protect people's privacy, no doubt, but the law also provides ways to facilitate sharing when it's necessary and when it is beneficial to the work we're doing with youth. For example, there is an exception to FERPA, which is the federal law that protects educational information. There's an exception under what's called the Uninterrupted Scholars Act that allows schools to share educational information with child welfare workers about their clients in care. That's a very clear exception that allows us to better understand how to support youth in foster care with their education. We also have under HIPAA, which is our Health Information Privacy Act, that there's exceptions for those who are coordinating on treatment, an exception where information is pursuant to a court order. And we're never asking anyone to just throw open the gates and share information irresponsibly or without care, but to bring together these multi-system groups to really talk about what information do we need, for what purpose, and how can we put protections around that information, and as you said, within the confines of the law, so that people are protected, but we can really benefit. Information sharing can almost always be facilitated by the use of informed consents. And sometimes there's an MOU established to allow for greater information sharing, again, balancing the protection with the necessity and the benefit of sharing information. It's possible.
So I want to amplify that. It's possible and it's necessary to navigate the collaboration that can be sustained. And I appreciate the detail that you've offered to that, Jessica. We do need to build it around what we need to know, not what we want to know. You've highlighted that in essence, we want to work with a presumption of non-disclosure. This is not a reckless exchange and sharing of information. It's an intentional identification of that which would inform a very crisis-oriented case plan in the moment. And all of that can be done. It's not only possible, I would argue it's necessary to support these dual status youth moving forward. And I appreciate that what we've created in partnership with Juvenile Law Center is an information sharing toolkit that provides some guidance on how you work through that process to find those exceptions, those realities. And I need to say this with emphasis, while still protecting the confidentiality, the privacy, the unauthorized redisclosure provisions that are afforded youth and families. There's a possible balance. You said possible. There's a necessity, I think, as well. Judge, we walked into your environment where I think a little bit more trust among the agencies, maybe not the immediate, we can't do that, was not part of your atmosphere. Can you comment a little about the information sharing issue for your cross-system collaboration?
There is a lot of misunderstanding about HIPAA and FERPA. I absolutely agree. And sometimes, even though I know what they believe is not true, convincing their attorneys, for instance, if our mental health agency says our attorney won't let us do that, that's it. I mean, I'm not going to talk them into something else. So it's really a working around what they need, making sure that if they need something signed before they can talk, that we have that at the table. We did come up with our own release that everybody went through, and it was a release just for those meetings right after the child was locked up, so everybody could talk the next day, and had the family and everyone sign off on that the next day and give us the authority to speak freely with all of us. And that seems to be what worked for us. I can tell you that might not work in the next county over. It depends on what their restrictions are or what their attorneys of each agency are telling them. So my advice would be, if that's the case and they need to have theirs signed, just have it at the table. Have it, have their release there. And the parents have not hesitated to sign releases throughout anything that we've asked. They just want assistance. So I don't think that will be a barrier in the end. So as long as you can get the agencies what they need so they can discuss freely.
Yeah, I think we leave this discussion, albeit brief, but we leave it with it's possible to construct a thoughtful, fair system of information exchange while protecting against unauthorized redisclosure. I would add that these consents need to be informed. They need to be voluntary. I know that I did a lot of sliding a release form across the desk and said, here, sign this. We're going to need this information. That's not informed. That's not voluntary. This can be thoughtful. Your advice also, Judge, what you constructed in Hancock may not work in Champaign County in Ohio. So that individual analysis in each jurisdiction to allow for the sustainability of what you construct around information sharing is critical as you go forward as well. I think, folks, we've had a rich discussion. You guys have shared your experiences. I want to offer just a couple of points that maybe get your affirmation. And of course, this is a podcast, not a broadcast. So I'll come back to you, even though you might be nodding your heads as I share these. But we have found over the years there are kind of core successful strategies. I think we've talked about several of them today, but the early identification and early intervention with a matched treatment service for these youth is critical to interrupt that trajectory going forward. One, the instant response in a collaborative way because of the rapid pace at which these youth reoffend or transition from placement to placement to placement, that the interruption of that trajectory has to be paramount in our goal and objective for these multi-system youth. That's two. Just what we spoke about, the lawful and effective transmission of information seamlessly to and through our agencies that is protected against unauthorized disclosure, but is used as a need to know to inform coordinated case planning and case management for these youth across our collaborators. The timely connection, which is not always possible, to these targeted resources that are necessary to be availed within our community. Sometimes we just don't have that particular targeted resource. Often we default to another, but over time, our collaboration can create that. That's a critical cross-system collaboration to identify those targeted services. And something we haven't had a chance to talk about, we won't explore today, but at least worth mentioning, the measurement and the reporting of success for both the process that we've put in place and for the intended outcomes that we're seeking to achieve for our youth to drive the fidelity and sustainability. Judge Johnson, you guys have constructed at least a methodology that ensures that you're collecting the data that you referred to earlier that will give you a tracking of the key outcomes that you've focused on. Am I not correct?
We did have a long discussion about what is success. And I think it's important to have those discussions and have everybody give their input and decide on that as a team.
And you're using some of that data right now as you come back together to make adjustments or to reflect what you need to do, or in your case, maybe even the opportunity to expand to impact an additional population in Hancock County. So just a verbal affirmation, if you would. Those are 5 key points that we would leave this audience with, most of which we've talked about today, that you would support as necessary to ensure long-term success for dual status youth and sexually exploited kids.
You got it.
Awesome. Awesome. Now you're both going to join me about 30,000 feet. Your expertise is unparalleled. Your commitment and your passion, I happen to personally know, is extraordinary. It's exemplary as well. I'm glad you would share your thoughts and your perspectives. But let me give you a chance to say, and I'll first go to you, Jessica. If you could change one thing about our youth justice system, what would that be?
Well, I do have a vision. My vision is that every person working in the system is someone who wants to be there, someone who loves children, who values children, who sees the potential in children, not just working in youth justice because their probation department or prosecutor's office or public defender's office or presiding judge assigned them a rotation there. But I want to see the roles in the youth justice system as highly regarded, specialized roles that provide the opportunity for extensive training about child development, trauma, and how to work with children. And these roles should be held by people who want to make a positive impact on children, recognizing that investing in and succeeding with children when we first have contact with them is the best way to ensure healthy families and communities in the future.
Thank you, Jessica. Judge Johnson?
Well said, Jessica. I absolutely agree. I don't have this problem in Hancock County. I want to say that specifically, but typically what we do with a juvenile court is we send our newbies. That's where we send everybody to learn how to practice law. That's where we send our social workers, go work with kids. I think we have it completely upside down. The criminal justice system, the mental health system. If you look at just the opiate issue that has happened, we first ran to the adults and we tried to fix that. In my opinion, we should have started with the children, because the children are the ones that are going to be living with it the longest. They're the ones that have suffered the trauma from living in those homes and the neglect. And we're just now starting to address that. That would be we need to start with the kids for the future.
Well,
Beautifully said by both of you. I want to close by just thanking you profusely. You are exemplary professionals. I'm privileged to have been working with both of you, but I hope that the audience will have been privileged by what knowledge, information, and obviously passionate care and concern for youth and the youth justice system that you've shared here today. Thank you.
That was really helpful information. Thank you, John, Jessica, and Judge Johnson. For more ways to support youth involved in child welfare and juvenile justice, check out our website, rfknrcjj.org, and click on the subheading Dual Status Youth Reform. And follow us on Twitter at RFK Youth Justice. Remember, we're here to present topics that are important to you, so feel free to email your feedback and ideas to rfknrcjj@rfkcommunity.org.